Good afternoon, and welcome to today's Covering the McGirt v. Oklahoma Decision Virtual Roundtable. This webinar is part of a series of roundtables hosted by the Native American Journalists Association that will discuss and examine the unique challenges of covering issues that affect Indigenous communities. Today's roundtable will focus on the recent landmark Supreme Court decision and how its implications have been covered in the media, and we are honored to host a panel of professionals close to this story. This webinar is being recorded and streamed on Facebook Live, and the recorded video will be posted to the NAJA website, the NAJA Facebook page, and the NAJA YouTube channel. This roundtable series would not be possible without generous support of our sponsors, the Ford Foundation, Knight Foundation, the Democracy Fund, Google News Initiative, and the Walton Family Foundation. We thank them all for their continued support. Our panel moderator is Graham Lee Brewer, a current NAJA board member and associate editor on the Indigenous Affairs desk at High Country News, and a regular contributor to NPR and the New York Times. Graham will facilitate this important discussion and introduce our esteemed panelists. Graham will be taking questions from the audience. Please use the Q&A option to submit a question, and it will be posed to the panel as time allows. Graham, the floor is yours.
Thanks, Brian. Good afternoon, everyone, and welcome to the Native American Journalists Association's panel on the McGirt decision. Tonight, we'll be discussing the implications of this landmark Supreme Court case, both in Oklahoma and across Indian country, with some legal scholars, journalists, and tribal citizens who know it best. As I'm sure many of you are well aware, Indigenous communities are not only often overlooked by journalists, they're often misrepresented. And the McGirt decision, presents some new challenges on top of all that, because not only is it an unprecedented case, but it exists in this very complex legal world that is federal Indian law. So hopefully this panel will offer a little bit of something for Native and non-Native journalists alike. Our goal is to open up some of the complexities and nuances of the case, and not only help you find important ways into this unfolding story, but also help journalists reporting for Indian country, and notice I said for and not about, help those journalists distinguish hyperbole and speculation from the on-the-ground real-world implications of the decision. So joining me tonight are Jonathan Chaudhary, a Muskogee Creek Nation citizen, attorney at Quarles and Brady, and ambassador for the Muskogee Creek Nation. Jonathan, welcome to you. Thank you for joining us. We also are joined by Matthew Fletcher, a citizen of the Grand Traverse Band of Ottawa and Chippewa Indians, publisher of the Turtle Talk legal blog, which I'm sure you've all found some solace in at time and time again, and a professor of law at Michigan State University. Matthew, thank you so much for coming. And then Angel Ellis, also a Muskogee Creek Nation citizen and a reporter at Muskogee Media, the tribe's media publication. I'm really excited to speak with these three people in particular, because I think we'll be able to not only talk about the heart of this case and its origins in the Muskogee Creek Nation, but like I said earlier, also its implications in Indian country overall. I'd like to start tonight, Jonathan, with you, and maybe you could just kind of give us a sense of what is happening right now, what is happening on the ground, not maybe just in the Muskogee Creek Nation in particular, but in Oklahoma overall.
Well, Madoa Graham, I want to thank all of NAJA and everybody that put this together, yourself included, and Brian as well, and Rebecca and everybody that's part of the NAJA team. This is an honor to address you all. Accurate reporting is so critical for Indian country, because so often our issues get mischaracterized. The reporting around McGirt is a perfect example of this. But for some great work from Native journalists, as well as some allies in the mainstream media, the messaging and the storytelling around McGirt would have been very inaccurate. So I want to thank you and thank Indian Country Media for its efforts to engage in accurate reporting. It's especially critical right now, because in terms of what's happening now, the next stage is, well, how do tribal nations implement McGirt? What response, if any, should there be from non-Native communities to McGirt? Accurate reporting is critical to all those discussions, and that's why I'm so thankful for the opportunity to work with you today and to join the esteemed fellow panelists that you put together. So what is happening on the ground? So let me talk very briefly about what McGirt was and what McGirt wasn't. And I think there will be a time and place for others to kind of dissect the case. I'm sure everybody on this panel can dissect the case in great detail, but the case wasn't about any land transfers. The case wasn't, as it was reported in many mainstream circles, wasn't about the eastern half of Oklahoma going to non-Indian hands, going into Indian hands, going to the tribes. The case wasn't even about the eastern half of Oklahoma. As we see in the actual court's decision, as well as the court's mandate, which applies the decision on the ground, the case was about one thing. It was about the Muskogee Creek Nation's boundaries and the impacts of a whole history of congressional actions and actions of the state on the integrity of those boundaries. And after looking at Creek Nation's unique history, the court found that Creek Nation's reservation boundaries had never been established. In making that finding, the court, I think in a remarkable example of intellectual honesty, applied the Solemn versus Bartlett test, which simply, as the first part of that test, asked the question, did Congress ever affirmatively disestablish or diminish reservation boundaries? And finding that Congress hadn't, Justice Gorsuch applied that precedent and found that the Creek Nation boundaries remain in full force and effect. And the implied takeaway from that is Congress and only Congress can diminish the boundaries of a reservation. And when it does so, it has to show its face to the world. That holding is counter to a lot of the Chicken Little reporting and Chicken Little commentating that occurred before the case was issued. And since the case was issued, unfortunately, there's been a lot of Chicken Little reporting and Chicken Little commentating that's continued after the case has been issued. But properly reporting on the case about what it was and what it wasn't is the first step in telling an accurate story that helps Indian country understands the opportunities and the challenges that arise from the decision. But moreover, because Indian country is usually more attuned to these developments in the law, moreover, accurate reporting helps tell an accurate story to the non-Indian public. Both are important, both are critical, and that's why I'm thankful for this opportunity to talk today. So among the different false narratives that came out of certain commentators after the case were as follows, and you'll start to see a trend here in terms of what agenda may be driving some of these narratives. First false narrative is that the case creates chaos. Well, actually the opposite is true. In applying a well-settled precedent grounded in U.S. constitutional law and U.S. case law, the Supreme Court brought jurisdictional clarity to the jurisdictional questions on the ground. The second narrative is confusion. Well, with that clarity, people know what a reservation is. We know what the rules apply to reservations. Rather than confusion, there's a clarity. Again, clarity is the answer to most of these false narratives about how rules are applied on a reservation. Another question is that McGirt presents a problem to be solved. Well, the only problem, as recognized by the U.S. Supreme Court, is a history of illegal deprivations and displacement impressed upon Muskogee Creek Nation, similar to the experiences of so many nations, as well as the history of dispossession and displacement. That history of dispossession and displacement imposed upon Creek Nation by the United States, as well as by the state of Oklahoma. That's the problem, and the solution was, properly recounting the history of constitutional law, recognizing that that unfortunate history didn't destroy the reservation. That's not a problem to be solved. Instead, what grows from that are opportunities to be shared, and let me talk about that. And the opportunities to be shared are, now that we have clarity in terms of what rules apply, Creek Nation can work as a sovereign to work with other sovereigns, as well as the private business community, that with this clarity, we can work with them all to create a better shared future. You know, Creek Nation, like so many nations, we were the first business people of this country. This clarity provides all sorts of opportunity. Finally, a couple other mischaracterizations of the case. You've heard time and time again that in addition to this being an Eastern Oklahoma case, somehow this is a 5 tribes case. Now, as Creek Nation, we have the deepest respect for the 5 tribes. You know, the Cherokee, Chickasaw, Seminole, and Choctaw have a shared history of removal, along with other smaller nations from the Southeast. We have a deep respect for our 5 tribes partners, but Gorsuch's opinion wasn't about the 5 tribes. I can understand that conventional wisdom leading up to the McGirt case all was of the mindset that the case would hinge on treaty language that was largely shared by the 5 tribes. The court's decision addressed that, but it went so much farther. It addressed allotment, the history of allotment that was unique to Creek Nation. It addressed all sorts of Creek-specific issues. Now, there may be a great amount of commonality between Creek Nation and the other 5 tribes in terms of some of those shared experiences, but there was nothing in the decision that says that this case applies to the 5 tribes or applies to Eastern Oklahoma or applies to any other nation. No, now those may be natural, logical follow-throughs, but there's a process that goes into place with all that. The Supreme Court's mandate that applies the decision to issues on the ground applies to Creek Nation. Now, there are steps that can be taken either through state acknowledgement or affirmation, or through court decisions, or numerous other models that can apply McGirt to the 5 tribes. But right now, the case is one of 2 things. It's a Creek Nation case, or if people are talking about the potential implications of the finding that Congress can't diminish a reservation, that a reservation isn't diminished unless Congress acts, well, that benefits all of Indian country. So it's either Creek Nation or all of Indian country. So that's a false narrative that this is a 5 tribes case. And then finally, that this is an impossible situation. This is just impossible. Well, the only thing Indian country has to fear is fear itself in terms of implementing the opportunities of McGirt. In terms of impossibility, people may point to some cases that involve kind of high-profile dismissals during this transitional period, or the lack of resources of the federal government or the tribe. Well, let me be clear. The state government isn't just rolling in dough either. Whoever has jurisdiction, the federal government, the state, and the tribe all have an interest in protecting all citizens and non-citizens within Creek Nation's boundaries. And frankly, that's what Creek Nation's been doing. Creek Nation has formed a commission under the leadership of Principal Chief Hill to address both internally and externally these implementation issues. Internally, this commission, made up almost entirely of Creek Nation citizens, is looking at every aspect of governance, from public safety to child welfare to economic development, to examine what can be done in collaboration with other partners, but what can be done to build into and grow into this newly affirmed sovereignty. I say newly affirmed because that's another mischaracterization. Nothing was created by this decision. Again, the Supreme Court just recognized that this authority, this jurisdiction, always existed. Although it had never been fully respected by the state, it always existed. So this commission is working internally to address all governance issues to fully implement McGirt. But there's also a critical external function of this commission, in which this commission is reaching out to the state recently, and there's been a request to Governor Stitt to sit down, coming from Chief and the Commission, but also to the U.S. Attorney's Office, to all the various mayors within Creek Nation's counties, and as well as the business community, to examine how best to take advantage of these shared opportunities for prosperity. So I thank you all as Native journalists for the work that you do to bring accurate reporting to this issue. There's been so much Chicken Little narratives that have been put out there. And as I went through those mischaracterizations, I would challenge the folks listening to this call: whose agenda does it serve to push those mischaracterizations of what McGirt is versus what it isn't? Just ask yourself, whose agenda does that serve? And that will put into context why certain voices have perhaps called for legislation to undo or roll back McGirt. The only antidote to mischaracterization is accurate reporting. For every one of those mischaracterizations, there's an accurate narrative that Native journalists have an opportunity to highlight and showcase. And for that, I'm deeply grateful for this opportunity to address all of Naja, to speak with you and join my fellow panelists on this healthy debate. Mado for this opportunity.
Thanks, John Deb. To piggyback on that a little bit, Angel, maybe you could kind of tell us a little bit about, as a journalist within the Muskogee Creek Nation, how you're covering it. Matthew and I have talked a little bit about this in the past, that a lot of the framing is kind of interesting from non-Native journalists when, kind of getting to what John Deb said, where there seems to be a lot of reporters trying to answer these questions of how to address the chaos, when there's not a lot of journalists asking questions about what is the government's responsibility to right this historic wrong that has been perpetrated for a century. So I wonder, in terms of how to frame your stories and the voices you include, do you have any advice for journalists? And are there any particular pitfalls that you see happening quite a bit?
Oh, okay, sure. Yeah, the most common pitfall, and I'm seeing this play out daily, and I kind of like to address the pitfall because that's the most obvious. And I think John really did nail it on the head, was with the sky is falling reporting. Just, last night, the news is covering a man released, the statute of limitations has ran out on a case, and they're pitching this to the public as this is all because of McGirt. And what they're failing to really report is the context surrounding the law in itself. And I'm not a great legal mind, but what I do when I'm framing this story, I say, okay, you've got this angle and I can see that you're going to this end. And the reporter even mentions that if people are dissatisfied that this person is free, they should contact their congressman. So I start asking myself, what does the law actually, provide for in these cases? I start asking myself, why for 20 years did federal prosecution fail to apprehend this suspect? Why did they allow the statute of limitations to run out before they ever apprehended this person? And would that statute of limitations mattered if he was white, black, brown, or yellow? So those are the framing that, I'm looking at it from an overall perspective of how to really find out where the breakdown in this system is. And every time I've approached one of these stories, of course, I'll go talk with or try to get comment from the federal, prosecutors, and their message is always the same. McGirt has upended our world, and we have so many more cases than we've ever had. And my kind of, compilation of that in my story is, just because you've done it wrong for 70, 80 years doesn't mean that it's not right now. You can't keep expecting to do something wrong just because it's hard for you. And I think that really was what the whole Supreme Court decision was about, basically. So when we're going out and we're reporting on all these issues, sometimes we're playing cleanup, and sometimes we're trying to clear up the confusion by actually digging farther than the mainstream media is doing. We're actually asking, what is the impact for our community, and how is our community being dealt with by the overall state or the overall federal systems? And that means you're having, as a Native journalist, you're having to do probably 4 times the work that the parachute journalists do. I have to reach out to the federal prosecutors. I have to reach out to the attorney general at my tribe. I have to reach out to the indigenous legal minds who really do know Indian law. And then I have to reach out to tribal leaders. And then I have to reach out to the overall community that we exist in and say, what is your pulse on this? So sometimes my deadline gets completely blown out of the water, and it does get difficult. But if you're going to do a good job and do these stories justice, you have to approach it from a multi-layer level, and you have to keep peeling them back. At times, it even does reflect that I asked the question, was my tribe prepared for this decision? Did we have everything in place? And sometimes we turn the critical eye on ourselves, but you can't really guess what the Supreme Court's going to do. And how do you prepare for undoing, a long time of injustice? So you really just have to look at what we're doing, what's been done, and you report that without trying to skew this to a certain end, so to speak. I notice a lot of journalists go to a place that just in the sheer realm of journalism ethics that I would never go. No matter if I'm reporting for mainstream news or indigenous news, I would never try to lobby people to go to their congressman to undo any Supreme Court decision. That to me seems like a really biased place to go. And it's against ethical, journalism principles altogether. Whether or not it's a McGirt decision or, Roe versus Wade, it's not my realm as a journalist to tell the people what to do and how to think. It's my job to give them all the facts in the proper context and let them make their decisions. So when I see the mainstream news media telling people, oh, this person is out of jail and it's because of McGirt, what I really have to do is decide, okay, did they just stop after they got a comment from U.S. Attorney Trent Shores? And of course, that's what he said, and they're done reporting? Because that's what they're doing right now. They're giving us the sloppiest journalism possible and calling it good and putting it out on the 5 o'clock news. I've even kind of spent a lot of time since the decision. I don't know, maybe it's a habit, a hobby, and maybe it's not even my duty or job and I should leave it alone, but I've been policing some of these stories and putting my own comments on there and pointing out the fallacies in these instances, because I think it's critical right now for our tribe and others who could be impacted. It's critical for us to empower our people with the information and not let them just be given, a spoon-fed, answer and left at that. And a lot of our people, since we live in this community that is overlapping, and we have mainstream on top of tribes and then states and then sovereignty and all this, it's really important that we push out into that realm as tribal journalists. It would be super easy to sit in our tribal complex offices, report from our own legislation, and just put it in our newspaper. But that isn't going to educate all of our people. And so we're taking an almost advocacy approach to delivering information. And if the news on Channel 6 can get 10,000 hits on one of their posts, well, I'm going to make a comment there and I'm going to fact check them. And so maybe those 10,000 hits will see actual information. Sometimes I'll drop a link just to be a little extra.
Well, I want to get to something Patty Lowe had mentioned here in the comments, and she's asking, what are the environmental law implications? And Matthew, I was hoping maybe you could kind of help me understand, or help us understand, how this isn't just a case for Oklahoma tribes or tribes in eastern Oklahoma, that the way that Gorsuch approached this particular decision by following the actual language of the treaty has some pretty broad implications for Indian country overall. And could you tell me a little bit about what you're seeing outside of Oklahoma and where you think that this decision might come into play?
Well, I think what we're seeing right now is there's going to be a pretty dramatic shift on how reservation boundaries cases are going to be litigated. There's a few kicking around out there. Within a month of McGirt, the Seventh Circuit reversed a trial level decision disestablishing the Wisconsin Oneida Reservation. And it was obvious under the the language of McGirt, that the trial court was wrong. And that's going to be happening. Those kinds of cases are closest to the McGirt kind of situation. But I think that when it comes to those environmental statutes, there are some federal environmental statutes that tie the trigger to jurisdiction to, quote, Indian country. Now, Indian country is a term of art that appears in the federal criminal code. So that's why we're talking about criminal cases for the most part. But on occasion, some of the federal environmental statutes tie the jurisdiction over Indian country to federal and or tribal jurisdiction, say for the Clean Water or Clean Water Act, Safe Drinking Water Act. In fact, Justice Gorsuch years ago, when he was a 10th Circuit judge, had a case out of Navajo where there was a cluster of tribal Indian trust properties, and the tribe, the EPA, was trying to argue that that cluster of trust properties was a dependent Indian community under the Indian country statute. And Justice Gorsuch and the rest of the 10th Circuit said, no, I'm not sure that this case affects that case, but what I'm saying is that that's an example of the kind of authority that is at play in the environmental realm going forward. Gaming, on the other hand, wouldn't really have much an impact here because that's a different jurisdictional hook. That's Indian lands as defined under the statute. So that would be lands held in trust by the tribe, for the tribe.
And I don't know if John, Deb, or Matthew, either one of you might want to jump in, but I'm really curious here in Oklahoma if you guys have any thoughts about how McGirt could influence things like Indian Child Welfare Act and in particular the NAGPRA, the Native American Graves Protection and Repatriation Act. Are there any implications that you think could play out here in Oklahoma in either one of those two realms?
Well, I'm happy to get into that, and but let me just kind of address one broader point that Professor Fletcher made. There are certainly implications to ICWA, to NAGPRA, and we can talk about that, and let's talk about it. But there's no doubt that there are going to be far-reaching implications in a lot of areas, but that's not a bad thing. That's not even a bad thing for non-Indians. I think the concerns about the far-reaching implications have been really, voiced by the folks who have financial concerns. Many of them just really not grounded in the actual bottom line, but folks possibly from oil and gas, but also other industries who would like to roll things back to what everybody thought was the old days with Creek Nation, but with other tribes as well. So whether it's economic development issues or ICWA issues or NAGPRA or environmental issues, the challenge of Indian country, and frankly the challenge of journalists, is to accurately convey why this isn't a scary thing, why this is a good thing for everybody involved. Indian country is replete with commercial zones that benefit non-Indian businesses and tribal businesses alike. It's replete with urban communities where non-natives live inside a reservation. I used to work in the Northwest. I'm familiar with Tacoma and the Puyallup Reservation. I've worked in the Southwest. I know how much business is done in the Phoenix Valley and commercial corridors there are, and how many non-Indians you have living on tribal reservations. A false narrative is that there's something unprecedented about, and actually Attorney General Hunter actually said this publicly, that this is really an unprecedented, I don't know if he used the term unprecedented, but it's a situation that's kind of unheard of. Indians and non-Indians working and living side by side in Indian country on a reservation. Well, come on. Indians and non-Indians aren't cats and dogs. We can get along, and we can get along for mutual benefit. So I'm happy to talk about NAGPRA and ICWA because there are examples of opportunity and mutual benefit there. But whether you're talking about environmental issues, even tax issues, working with so many tribes that have cooperative agreements so that tax revenues are shared and properly assigned for governmental services that are worked out through intergovernmental agreement that's Indian country. That's what business in Indian country is. And anybody who practices in this area or has a background knows that this isn't a scary thing. So I sucked up a lot of time and oxygen with that. I don't know if maybe I could turn it over to Professor Fletcher about NAGPRA and ICWA. I'm happy to talk about those as well, but I wanted to make that broader point. Yes, there is some, it's not change, it's just a change in mindset. The court recognized these our reservation hasn't been disestablished. We imagine that analysis will be applied elsewhere, but that's not a bad thing. That's not a scary thing. So,
Matthew, do you want to jump in there?
Yeah, I'd love to. And just in agreement with everything John and Def said. And I wanted to point out something before I talk about the Indian Child Welfare Act. Something that Angel said earlier. As a journalist, she has to do 4 times the amount of work. And I think Indian lawyers really feel the same way when you're trying to talk to a court that doesn't hear many Indian law cases and really doesn't know anything about Indian people or tribal law or anything. We have a lot of work to do to educate the courts on what's going on there. And, you know, that the thing about McGirt that one of the many things about McGirt that I really enjoyed and liked was how the majority cut through the bullshit, because that's really how Oklahoma was arguing this case. And I think this is really one of the very few times that the Supreme Court did not succumb to the temptation of following the bullshit of state, local governments, the federal government. They really, you know, the state of Oklahoma made a lot of very ridiculous allegations about the consequences of this case. I think early on they were even saying tens of thousands or thousands of people would immediately be released from jail, which is just farcical on its face. But you know, that's the kind of argument that you can get away with at the Supreme Court when you're talking about Indians, because they don't know anything and they're deeply skeptical of Indians. And you know, when a state or local government or the federal government makes that argument, the Supreme Court institutionally is predisposed to believing that argument. And I know you wanted me to talk about the Indian Child Welfare Act implications, and I will mention that for a bit. But one of the cases in the last 10 years that reached the Supreme Court that I firmly believe was decided in the media was the ICWA case on a baby girl that went to the Supreme Court. After the lower court issued its opinion, the adoptive couple filed a cert petition and immediately went to the national news media, Dr. Phil, they went to Anderson Cooper, and they made this a national media circus. And that is a pattern that we see in ICWA cases that's really quite troubling. And there are tons of ethical issues relating to lawyers having to do using that kind of influence and persuasion. I firmly believe it impacted the decision in that case on the court in 2 levels. One, they never should have taken that case. There was no reason whatsoever to handle a case like this. And the second reason is, second point is when they, you know, made the decision in the end, 5-4 against the application of the act. And that's something that as lawyers, we don't have a lot of control over as to what we can do to educate the court and what they will actually listen to. And I hope McGirt is a real step forward in terms of how the court views the realities on the ground of Indian country. They are pretty open in admitting that they don't know much. And, you know, we've seen cases like adoptive couple. Years before that, City of Sherrill versus Oneida Indian Nation of New York, which was decided not on the law, but on a perception that tribal power was going to be disruptive, and whatever that means. So that's, I think, one of the great things about McGirt, and I hope that the aftermath of McGirt, this weird backlash enabled by some journalists, I'm reading things today about journalists describing what's going on the ground as in an alarmist tone. But a couple of points on the Indian Child Welfare Act. The jurisdictional hook there really is very similar to the issue at McGirt. The jurisdictional hook in ICWA is Indian reservation. So if you have extant reservation boundaries, as the Muskogee Creek Nation does, then everything within those boundaries that involves an Indian child where a child is domiciled there is within the exclusive jurisdiction of the tribe. It doesn't matter if the child is living on Indian land or non-Indian land, the reservation boundaries are extant. Now, the nice thing of what I've heard out of Muskogee Creek and out of the other five, the so-called five tribes as well, is that they had already engaged the state and local governments on an agreement to deal with Indian Child Welfare Act issues. ICWA itself strongly encourages the state and the states and tribes to reach negotiation, to negotiate and reach agreement on ICWA jurisdictional issues. And we didn't expect there to be a huge impact, and how that was already happening anyway on the ground. So my sense is ICWA actually is covered. I mean, who knows how that's going to work out, but there was a pretty decent track record going in. So at least in Oklahoma, it didn't seem like the ICWA jurisdictional matters were going to be all that terrible. And yes, Eric mentions my background. That's the Bradley Indian Mission in Allegan County, Michigan, Potawatomi baseball team from about 110 years ago.
Yeah, I kind of want to add something Angel mentioned earlier, just kind of, you mentioned getting the pulse of the tribal citizens and people in and around your community. Tony Elkins has this, I think, pretty good question about, limited resources. So, Tony's mentioning his own tribe, the Comanche Nation, and how I think a lot of people on the ground do have some kind of limited resources and limited understanding. I was kind of curious, just like in the community and for the community, are there any particular areas of the implications of this case, things happening that you think the media would be much better off like focusing on, and that, could help explain the situation to those community members in a way that's tangible for them?
Yeah, I mean, one of the major investments that my tribe has made is this multimedia, multifaceted reporting. And it can be kind of high-paced for the social media crowd, but we absolutely have citizens in areas that have, many of them have limited resources, and we have plenty of elders who do not pick up iPhones and smartphones. And so we had to take our budget and break that out into how to deliver the most expedited coverage to the most broad spectrum of needs, because our reservation is big and it encompasses Tulsa, which, parts of Tulsa, which has T1 connections, and people, might have access, or they may not have, hotspots and Wi-Fi at home. But we're seeing that our tribe made this investment to do, a traditional newspaper that is mailed to citizens free of charge. It's twice a month. We were running once a month, and we found that was really just playing catch up, and people were missing important information on, what legislation was coming up, or what, they might need to ask of their council people to best represent them. So we bumped that up to twice a month in order to keep a better pace with information and getting those to people who still use a traditional newspaper. We've invested in putting an hour TV show on CW19 with a network in Tulsa, which costs dearly. We're paying for this, and that's another thing with our tribes making these investments and informing citizens. We have to be real intuitive right now, since it is the media that mainstream media that is at war with this narrative. We have to be real careful who we're investing in, because it's really hard to swallow when you're pumping money into advertising or a television show on a network where you might watch the news and they might be saying McGirt is the end all be all, and then you should all run for your lives. You know what I mean? So this is kind of something that we have to really be conscious about. So we're trying to produce more to YouTube and avoid empowering these organizations that, with our tribal dollars, that are kind of hell-bent to take us down, And so we're going to package that. We're investing in our own people, giving them the skills, technology, and ability to do this work. And that is serving our citizens better, because we're kind of spread out over, 11 counties, some of them partial counties. And so we're trying to really capture the data, look at what needs are where, and deliver it to where it's best suited to be. The breaking story has been mentioned here in the comments. That's the latest one, where they're kind of flying off the handle saying that, this is horrible and it's because of McGirt. And the first question a journalist really should ask of this case, a serial rapist after 20 years has been brought in, wouldn't the statute of limitations have ran out for anyone? And so we're going to look at what our citizens are kind of understanding, because they call us, they actually do. This is kind of what's really great about being this niche little reporting environment, is that we're part of this community and we're reporting for it. So they talk to us. Some of them are my cousins, and some of them are just great friends who will reach out and let me know what they need. And that is the most extreme value you can have for being an Indigenous journalist, working in an Indigenous environment, and really being connected to the community that you serve. Total opposite end of the spectrum from anything mainstream, but that level of accountability is really high as well. And that's why we go above and beyond doing that work, because I'm going to hear about it at the next, Wild Onion dinner if I don't. And it's important because they need those answers. Right now, ICWA is such a hot topic. Our community, if you paid attention to social, a combination of that and the text messages that I got requesting me to look further, they were really split on what we should be doing with ICWA. When our legislators were trying to adopt policy to allow agreements with the state, it had to go through twice before it passed because our citizens were concerned. We've just been empowered and reaffirmed in our reservation status. They do not want to see anything that looks even close to relinquishing any of that sovereignty. So they kind of, fire speed dialed their council reps, and they said, whoa, don't do this. And it went down and it didn't pass. Well, then it turned out to be something that our Child Protective Services Department needed to ensure that the continued care stays the way it is. And so they resubmitted it. And then I think that we did some coverage kind of helping people understand what was going on, and that we've always, as a sovereign, negotiated with these entities, and that hasn't been any kind of negative effect, but from the sources I had, they said that it does give the kids continuity of care. And so we reported that. And then the second time this legislation went through, it passed, all the council reps were on board. We had, the attorney representing us in McGirt speak to our council and say, this is imperative, and it's nothing scary. And at the end of the day, when the tribe needs to retake control of any of these cases, that opportunity is there. So then everyone's more empowered with the information, and the continuity continues and kids are taken care of.
I'm sorry, you make a really good point. I did want to touch on is that if you're a non-native journalist and you're covering this, and you're not familiar with the agreements that already exist between the state and tribes, and you're not following every turn of the screw with the tribal council of the tribe you're covering, you're probably doing it wrong.
Absolutely.
Because I think it's important to remember that these tribal councils are passing laws, they're listening to their citizens, and they're trying to navigate a really complicated process. And actually to that point, I kind of want to touch on something Julia said in the comments here. John and Deb, can you talk a little bit about, there's always kind of hanging over this case, there's always been this argument from the state and federal government that oil and gas will be really negatively impacted, that industry, well, we all know that how important that industry is to the state of Oklahoma, the economy here. Can you talk a little bit about how exactly will it affect that area? And I think Governor Stitt creating a commission to discuss this case that was comprised almost entirely of oil execs, I think kind of speaks to how aggressive the other side of the argument is being on that particular area.
Okay, sure. Two things. First, in all honesty, it's too early to tell. Okay, the reason it's too early to tell, Oklahoma has been operating under, and as we saw in the court's decision, kind of a wrongful in many ways, but a purposeful framework of very complicated federal and state laws that apply to oil and gas in Oklahoma specifically. When I say wrongful, I just mean in the sense that I think many folks operated under this idea that, this wrong idea that the reservation had been disestablished. And from that wrong idea, a whole patchwork of laws, state, federal, regulatory, apply to Oklahoma. It's going to take some time to unpack that. But folks shouldn't be driven by fear. I mean, many tribal nations are very supportive of responsible natural resource development. And as I said before, there may be new parties to the table to discuss how to engage in responsible development, but that's not a bad thing. There always should have been those parties there. So that's one thing I wanted to say. There may be some impacts, but that doesn't necessarily mean that will affect the bottom lines of anybody involved. It may come in the form of, just ensuring that everybody's on the same page. This stuff takes time to sort out, and you first approach it, you exhaust all cooperation and collaborative options before talking about anything else. So that's the answer to the first part. I mean, that's the first part I wanted to address. But the second part brings up a larger question. An earlier question you asked, Graham, was, what are some big stories that we should be talking about? Well, on August 13th, organizations, national and regional organizations, effectively representing pretty much the vast majority of tribal nations in the lower 48, came out in unity and uniformed effort to alert the Oklahoma congressional delegation about their joint concerns about any rush to legislation undermining the historic decision in McGirt. That's huge news, huge news. I mean, and those organizations included the National Congress of American Indians, Association on American Indian Affairs, National Center for American Indian Economic Development, United Southern and Eastern Tribes, Midwest Alliance of Sovereign Tribes, Northwest, affiliated Northwest Indian Tribes, ATNI, affiliated tribes of the Northwest Indians, Great Plains Tribal Chairmen's Association, Intertribal Association of Arizona, on and on and on. Barely a blip in mainstream media. I think the AP did a byline. Fortunately, I think Indians.com, Indian Country Today, a few folks reported it, as well as some tribal newspapers. But this is major, major news. Why was there such a concern about a rush to legislation? Were people just, reacting off of bad information? No, there is actionable information that INHOF has reached out to stakeholders, 75 approximately, none of whom are tribal nations, soliciting feedback by a deadline that recently passed, August 21st, to get their input on how the McGirt decision impacted them. And this was being done for the stated purpose, and Inhofe spoke on podcasts, on a podcast, he gave public statements for the stated purpose of crafting a legislative solution to McGirt. A solution only exists if there's a problem. Okay, by definition, you can't have a solution to something that's not a problem. So the fact that Inhofe has already reached out and the Oklahoma delegation has already pointed out that they're working together for legislative alternatives, and we're all familiar with the mishandled and botched rollout by the state AG, which purported to claim intertribal unity on a proposal for legislation or a framework for legislation. We're familiar with that, but the story needs to be, why are folks even breathing the possibility of legislation when it's clear through all the commissions that Creek Nation and other tribal, I think Choctaws is called a task force, Cherokees is called a commission, the state has a commission. We're all trying to work together, both internally and externally, to explore intergovernmental agreements, to explore how to implement McGirt as collaboratively as possible. Why in the world would the first order of business after McGirt came out be to say, well, what kind of legislation is needed to solve McGirt? Well, it goes to your original question. I believe that there are some fears, largely ungrounded, driven by certain industry corners of industry. And if that outreach to stakeholders were non-tribal is indicative of anything, the discussion about legislation isn't as much about concerns about public safety, but it's concerns about commercial interests. And that's why you see a letter of the nature that we saw on August 13th from effectively all of Indian country saying, wait a second, if you touch McGirt, this could impact sovereignty, treaty rights, and jurisdiction for tribal nations throughout the US. That's a huge story. That's a huge story, and I would, suggest that journalists who are committed to accurately reporting on this issue follow that story and see where it goes, and see where some of the narratives about the need for legislative change really come from. There's a lot to unpack there, but oil and gas may be part of that. I think anytime you have a major decision that clarifies the legal landscape and the legal rights of parties on a national basis, that's going to be seen as disruptive and as a threat to their status quo. I think about the US versus Miranda case and its impact, and its long-term impact. I mean, if any of us get arrested, we want to make sure our rights are protected. So I think now, with the passage of time, most people can say, hey, this is a good thing that the police have to read me rights when I get arrested. But when it came out, the storytelling and the messaging, the sky's falling narrative of folks who didn't want that case to go the way it went out, was all about, oh my goodness, criminals are running loose because of this fruit of the poisonous tree doctrine under Fourth Amendment case law. And the short version of that is, if there's a Fourth Amendment violation, the courts often will say, while there may be injustice done with this specific defendant, the rights of the public in protecting Fourth Amendment rights are so critical that we'll understand that there may be injustice done for this defendant, and heartbreaking as it is, this is horrible for the victims of that defendant, heartbreaking as it is, but we understand if we don't do something to protect everybody's rights, the entire society will suffer. Now, McGirt had nothing to do with the underlying case. I'm just bringing up that analogy to say, when you have important cases of constitutional import, like McGirt, there's going to be a period of transition. And the folks who have an agenda to frame things in a way to go back to the pre-McGirt way or a pre-decision way will always cherry pick the poster children of the bad repercussions of what happened without saying, wait a second, the Supreme Court made this decision for a reason. It's because of a history of illegal action and frankly, bad acts and bad faith. The answer isn't rolling things up to go to the old way. The answer is to recognize that intellectual honest act that the court engaged in to do the right thing and use that as an opportunity for shared prosperity. So with the journalists on the line today, I would just submit that the Indian country united effort to brand this case as the unity decision, rather, and people talk about the McGirt decision or the court's decision, that letter branded this case as the unity decision because it shows a unity not just within Indian country, but between Indian country and non-natives, a unity and an opportunity to engage in shared prosperity. That's a story to follow. And one last thing, I'm sorry to get on my soapbox, but I appreciate the pressure there is that mainstream media often brings to bear to frame things in as sexy a way as possible. And certainly when individuals are approached about working on an op-ed or a piece, you know, a lot of outlets say, well, can you focus on this angle or that angle? Those mischaracterized narratives that I kind of touched on in the early part of my presentation, in addition to being wrong, they have the unintended benefit of being a little sexier than, I mean, you know, shared prosperity and collaboration is always less sexy than chaos and danger and fear. But it's so hard not to take that bait when trying to engage in a larger platform of national media. My hat is off to native media for its effort to walk that line. Understanding engagement with national media is important, but not at the cost of journalistic integrity, not at the cost of seeking the truth. So sorry for such a long soapbox. I know I covered a lot of ground, but those are some points that I wanted to touch on.
I think you make a good point. I'd like Matthew, if you could add to that. I think I would agree with you that a lot of the coverage isn't asking if a congressional fix or whatever you want to call it is necessary, but why. And so Matthew, I know that you and I have talked about how, you know, it's your opinion that you would agree with a lot of Indian country that Congress does not need to step in here. And I wondered if you could explain that perspective a little bit.
Sure. So my sense going into this case, I've been hearing about this case for 10 years now, and there's always been a lot of trepidation about it. But you know, there was a lot for Muskogee Creek Nation to lose, like any tribe to lose with a reservation boundaries case. They can be existential cases, but you know, the tribes can also you know, enter into agreements to try to avoid those consequences, right? And that is no doubt in my mind, the Creeks did all of that work in advance, as I've mentioned before. So what is interesting, and I think Patty Lowe from Wisconsin asked this question earlier, because you know there's a track record of the Supreme Court issuing an opinion and Congress jumping right on it to modify it or codify it or reverse it. And you know, that's just sort of the interbranch, you know, communication between, you know, how the branches of federal government work. So we've got a history of, say, things like the Indian Gaming Regulatory Act following the Cabazon ban case from 1987. And as I said in the chat, that I don't think that is a bad or likely outcome in this case. IGRA had already, or versions of it had been in heated negotiations in Congress since at least 82, 83, long before the 1988 decision, or 87 decision and 88 enactment. On the other hand, you have something like the Duro fix. When the Supreme Court decided Duro versus Reyna, the Supreme Court within months issued a fix, a Duro fix, because the court simply got it wrong. And that was to the benefit of tribal interests. So there is a possibility at any time the Supreme Court issues an opinion where Congress can come in for whatever reason. You know, Congress is a political animal, and we don't know what those reasons might be in any given moment. This decision, to me, if you cut through the wheat and the chaff and all of the rhetoric, you know, I'll quote a lawyer, a good friend of mine who's a lawyer for one of the tribes there, and one of his clients of tribal legislature, one of the tribes asked what it meant for that tribe. The lawyer just said, just keep doing what you're doing. You know, that, you know, you're already cooperating and working with local governments. You were doing the things you were doing. You know, there are some things perhaps you can push going forward, but it's not like this huge earth-shaking decision. And that's what's amazing about it, is that even now, months later, there's still news articles saying half of Oklahoma is Indian land, not just Indian country, which is a totally different thing. And it's coming from places like SCOTUS blog, who normally do not, well, I don't know if they normally do engage in, you know, hyper reality, I guess you could say, but they're all trying to get clicks. And Jonadab is right. I mean, a lot of this is driven by how many people will click on your website, and you get paid or you get revenue based on how many clicks you get. So it's absolutely natural to exaggerate the impact. But there isn't that much of an impact. There isn't one that maybe we're going to start seeing some of an impact that we don't know, given how things play out. But for Congress to jump in because there's so much uncertainty at this point, in this case, doesn't make sense to me on a practical matter, because the tribes and the state and the governments have already addressed most of these issues to begin with.
Yeah, and whoever wants to jump in here on this one, but correct me if I'm wrong, but I mean, we got cases like the Sean Bossy case in the Chickasaw Nation, which is very similar to McGirt and Murphy in terms of the degree of, it's a Major Crimes Act case. Jonadab, maybe you can answer this question, but like in terms of the other four tribes, like to Matthew's point, will those processes naturally work out with those other tribes the way they did with the Muskogee Creek Nation and the Murphy and McGirt cases? Could the tribes effectively resolve those issues themselves through their own legal channels?
Absolutely. Sorry, I'm chewing gum here. That's a bad habit. So they're going to work out, and it's going to get to the same point, whether or not there's a lot of litigation or whether or not there's a lot of cooperation. And the ideal situation would be to get to that inevitable point through cooperation rather than litigation. Let me give a little background on that, and others may even have more background than I, but the Little Chief case came out decades ago, involving the extent to which tribes could have, a couple specific tribes could have their own tribal court systems and not be governed by CFR courts, as they're called. Well, the question immediately became, after Indian Country won that tribal specific case, what's the application to Oklahoma? And there was a concern about chaos, or some chaos back then, but basically I can't remember the exact details of the statement that the state would recognize application of the case to tribes in Western Oklahoma, but it was done. There was concern about widespread litigation. There was some, but at the end of the day, there was some agreement from the state. Right now, there are numerous ways for the other tribes that are likely impacted by McGirt, who likely have similar histories, to achieve recognition. I mean, legislation is by far the least, the least efficient and least beneficial approach. You can have an agreement by the state saying, hey, we agree, your tribe's never been disestablished, or your reservation's never been disestablished, so we're going to operate under that understanding. There's no statute that's needed for that. Short of that, if the state doesn't cooperate, this is what I mean about ending up at the same place. You could litigate it. You could litigate all you want, and in all likelihood, if that analysis is taken to its logical extent, it will apply to a good number of the 5 tribes, but maybe other tribes. And again, as I said before, that's not a bad thing. Or you could rush to Congress and try to engage in some rush legislation without really letting agreements work out and without understanding how this may impact other tribal nations. Of those options, cooperation and collaboration are, definitely ideal. And as Professor Fletcher mentioned, this will impact tribes outside of Oklahoma. Again, not a bad thing. But to answer your question, Graham, this is going to be something that each tribal nation will have to look into their soul and decide do I support legislation, or do I support doing whatever I can to protect against legislation? And that part of that's going to be figuring out how McGirt applies to them, And legislation is not the only tool. It's certainly probably not the best tool. There are all sorts of things that can be done through recognition by the state, or short of that, court action that can get you to the same place.
I just wanted to quickly address one of the things that Nina had asked earlier, was how to track the commission and the recommendations. I would just, again, emphasize that these are all tribal governments. So they all, have usually publicly accessible meetings and things like that, but they also hire public information officers and people who are paid to answer your questions. So I think the best way to get into those issues would just to be building a relationship with the communications peoples at each individual tribe. I did want to talk a little bit about, and whoever would feel good to answer this question, please jump in. But I do think that there probably are going to be a little bit of growing pains as the tribes try to adjust to this new system. I wonder what the panelists kind of see happening there. I know, like, for instance, my tribe, the Cherokee Nation Attorney General Sarah Hill, was saying that she's definitely going to need to be hiring more people in her office. The Light Horse Police Department has said that they'd like to hire a lot more police officers. So in terms of like how that process will work out, and I guess, I think it's going to be a little bit of figuring out some things as you go. Do you guys have any thoughts about how that process will play out, and any difficulties that might arise as a result of this, fairly significant change to the system?
It's already playing out actually in the last month, and this is the headlines that you won't really see anywhere else but in the Muskogee Creek Nation's newspaper. But like, the Tulsa World isn't reporting that the Muskogee Creek Nation has made millions of dollars in investment in the first month post McGirt to increase the number of light horse officers. They're hiring dispatchers, they're outfitting these law enforcement officers, and they've made over 40 interagency agreements with other entities already, policing our reservation. And they've made these agreements with the understanding that the tribe has, jurisdictional, boundaries, and they're going to work together. And what we're seeing happen, and we're hearing this reported from our Light Horse chief, is that they are fielding calls right now to the Muskogee Creek Nation in a really high volume. Anytime they've identified a Native person, and this is another thing us journalists have to really watch for. How are they identifying these Native people? Because I've heard it from both sides. And I've had police officers tell me that they're going to pick up the phone when you call 911 and they're going to say, "Are you Indian?" And that's going to determine how they handle your call. And I'm like, let me know when that plays out, because I'm going to get it on camera and I'm going to stick that somewhere. But turns out that hasn't happened yet. But we're seeing the other side of that, where these entities are seeing the value of being able to shift some of their volume to the people who are trained to deal with it, who have the budget to deal with it, and it's happening and it's playing out. And this is not something that's making the Oklahomans headlines. It's not making, the Tulsa World's headlines, but it's coming to fruition. And we're hiring right now almost 30 new officers. And that's a dramatic increase for us. We're also seeing that the tribe has hired its civil judge, and they've filled judge positions. So we're seeing our legal system become, more efficient, and it's happening maybe through a little bit of growing pains, like you mentioned, but it is taking place. And it's because maybe these things should have been, bitten off in little bites and been enacted in action before. But if it takes this Supreme Court affirmation to empower us this way, then let's do it. And another thing that you don't see reported in mainstream media is that many of these county jails are now going to receive $69 per person who is an Indian person per day. So what value is that to a rural community who is struggling to house a jail and do it properly? But now the tribe is stepping in and it's taking care of part of that burden, at least. So there are very good foundations being laid here. It just took this pivotal force to kind of put it into perspective that people understood. We've been saying you're on the reservation for a really long time. Now they believe it, and now we're working together. That's really the only difference once you cut through all of that, baloney.
Yeah, no, that is a really, really great point. I'm really glad you mentioned that. I think that, we see that in so many areas, whether it's, hospitals in Eastern Oklahoma, the money that the Cherokee Nation license plate program gives to education systems. So there are really robust agreements and compacts that already exist all across Oklahoma. I'm recognizing that we're getting close to our end time here. I'd like to maybe just give each panelist like 3 or 4 minutes to say anything else that they want to say, add any extra context. Matthew, if you don't mind, I'll start with you, and then when you're done, Angel, and then finally Jonadev, if you want. Jonadev, if you want to say something?
Yeah, I'm sorry, Graham. I just wanted to build on what Angel was saying, just really quick before final statements. I agree with everything she said. Frankly, I agree with everything everybody said so far. But you're right. You're not going to hear those. You're not going to hear reporting about those good facts, but I can't predict the future. But since we have so many journalists on the call, or what you are going to hear about is other poster children for why McGirt should be unrolled. You can rest assured there are going to be folks who, whenever you have a transitional time, and we're in a transitional time, and this is an opportunity to build into the jurisdiction that's been affirmed. The people that want to go back to the old way are going to find poster kids. And it's unfortunate, it's heartbreaking for whenever there's any victim of any crime. But all these crimes that aren't Creek Nation, weren't brought by caused by Creek Nation or even caused by McGirt, they're going to be held up as reasons to roll back McGirt. And I just wanted to kind of flag this for all the journalists online, that this is going to be clickbait, so to speak. And it's going to be, unfortunately, even worse than clickbait, often agenda-driven clickbait. The agenda being there are folks who want the old ways to be returned. And so I just wanted to kind of point that out in terms of what we're going to see in terms of stories. We're going to see poster kids for horrible things happening. And now we're prepared.
No, I think the baby Veronica case was a really great example of exactly what you're talking about. Matthew, did you want to take a few minutes to just add anything else that you'd like to add?
Yeah, I think that, just kind of rehashing what I said before, when I was in college, I remember reading a sort of journalistic theory, political theory from a guy named Walter Lippmann, who coined a phrase, maybe I'm getting the name wrong, but somebody coined a phrase, emotionally potent oversimplification, which is a phrase that stuck with me for a long time. It's, you look for something that really sticks in people's craw, and you use a little what I previously referred to as bullshit, which is reckless disregard for truth. And those Indian people and Indian tribes are really vulnerable to that in our society. And there was a question earlier about how to respond to social media, and I really don't know the answer to that, because that is the world of emotionally potent oversimplification. And that's the part for me that is just frustrating. And I imagine it's incredibly frustrating for journalists who are trying to work ethically, to be surrounded by all this noise that is much of it is just garbage. So, I don't have a lot to add. I appreciate the opportunity to come on here. This has really been a learning moment for me. I appreciate it.
Thanks so much for coming, Matthew. I really appreciate your time. Angel?
I just really want to end on the note to encourage every single one of us who are out there covering our Indigenous communities to use every one of these scenarios that present false facts or fallacy. Use this as the opportunity to document, educate, and advocate for your community's knowledge, because every time there's been a question brought to me by someone, I have found an ability, like a really good story at the center of it. One of my friends came to me really scared. She's a real estate agent. This ranch that she has for sale and she thought she had a buyer for, he's backing out and he doesn't want to live on a reservation. And I asked this woman where he lived before, and it turns out that he lived on a reservation already and he didn't even know it. So now the story is, there are places that exist and you don't even know that you're living on the res, but just use these opportunities to really, focus in on what is important to Indian country, and give those folks out there who might be starting to finally pay attention to us because of a Supreme Court ruling, the opportunity to really understand us from the inside and control that narrative yourself. Don't be influenced by short, shoddy work that doesn't really provide the full context. And let's really, control our own story here and show people like what the actual context and facts are about.
Thank you, Angel, for coming too, and good luck out there on the ground.
Thanks for having me.
Jonadab, do you want to end us off?
Sure. Again, I just want to take the opportunity to thank Naja and thank my fellow panelists and everybody involved. It's truly an honor to be with you. I just wanted to say I feel for Native journalists in the double responsibility that they have to carry in terms of doing the work any journalist does to get the story right, but also, unfortunately, having to educate fellow journalists, namely mainstream journalists. That's you don't get a pay bump for that, and that's certainly not part of any compensation package. But that's such critical work that you do, and not all the mainstream journalists are. There's not necessarily a bad purpose involved. Some of the folks are trying to save their institutions that they're at and save dying mediums, and revenue is critical to keeping the certain institutions open. Some of them may not know any better, but some of them may actually enjoy kind of trivializing the legalities or the facts involved. And there's going to be a whole range of folks, and you educate who you can. And recognize you can't educate everybody. As applied to McGirt, though, the stakes are really, really high. Professor Fletcher mentioned IGRA. We've heard about the Duro fix. You can go all the way back and the days of allotment. And we think about allotment as applied to Oklahoma. There were folks who actually wanted full reservation disestablishment when allotment was passed back in Oklahoma. But because of the advocacy of folks like, at least for the Creeks, we have Jito Harjo and others, and all the 5 tribes have other folks who fought against it. The Congress stopped short of full disestablishment back then. Certainly a lot was lost, but a lot was kept because of the advocacy of folks who fought against this. Well, we all collectively have PTSD from, not getting a fair shake by Congress for so many years, this whole history, litany of broken treaties. And things still aren't perfect by any means. They're still not perfect. But it is 2020. It's not 1988 when IGRA was passed. It's not, 1906 allotment period. It's not the termination period. Certainly a lot of work needs to be done. But as people think about whether or not legislation is inevitable or wanted, this isn't the old days. Indian country has a voice, and allies understand the benefits of working with Indian country to have a better future for non-Indians as well, whether you talk about in terms of environmental protections or economic development opportunities. We have more muscle than ever before, but we have more allies than ever before. Things aren't perfect. I don't know if they ever will be, but fear should not drive this discussion about whether or not legislation is inevitable or wanted. This opportunity to hold on to sovereignty, recognizing whatever's given up now will probably never get back. I mean, talk to folks at PL 280 tribes about whether or not, PL 280 was a great idea, whether or not they've ever really been in a position capacity-wise to pursue retrocession. Jurisdiction lost is rarely reacquired. And think about the moment that we're in, and the moment that we're in historically, but also globally, there's never been a better time to support a protection of the sovereignty and jurisdiction that was affirmed in McGirt than now. And now is the time for Indian country to rally together to protect McGirt, put into place, in a place on the shelf of the American consciousness where other watershed cases are, and say, you know, all tribal nations, we can have our own one-off legislations, but that can and should be done outside of McGirt. McGirt is our untouchable decision, and let's build on a better future from there on it. And I think that those are storylines that should hopefully drive the narrative rather than these Chicken Little storylines that are often agenda driven. I just wanted to again thank everybody for the opportunity to join in. It's truly been an honor.
Thank you, John Dev. I really appreciate all that. I want to point out something that Jody Rave Spotted Bear said in the comments, that, you know, if you're a member of the mainstream media, you know, it is entirely possible for you to partner and cross-post with tribal media and work with tribal reporters who are on the ground in these communities and know them well. In fact, I think High Country News, we found that can be a very effective model. I'd also just like to emphasize again that if you're going to write about McGirt, that you should really be considering writing for the Indigenous communities that you're covering and not just about them. What kind of information about McGirt is really going to help them understand it and help these communities grapple with this really incredible change. So, and I'd also add that I apologize if we didn't get to your question. My email address is Graham, Graham, the letter B, @hcn.org. That's HCN for High Country News. If you need some help, please feel free to reach out. I'm happy to help try to connect you with somebody who can answer your questions. With that, I'm going to hand it back over to Brian Pollard. Thank you all for coming. Thanks everyone for participating. I really, really appreciate your time.
Thank you.
Mido.
All right. Thank you, Graham. And thank you again to our panelists. We appreciate their time and generosity. This conversation has been tremendous and powerful. I'd also like to thank our audience and everyone who attended, and would encourage you to subscribe to the NAJA newsletter. Visit naja.com and follow us on Facebook, Twitter, and YouTube for announcements about future roundtables in this series, and remind you that this conversation will be posted to our website probably in the next few days. So if there's a part that you missed and you want to go back and review it, you can find it on naja.com. So this concludes today's virtual roundtable. Again, thank you to our panelists and thank you to our moderator, Graham. We will see you next time.